evening to all of you friends. A very good evening to all of you. Welcome to BYJU'S Exam Prep, the most comprehensive preparation app for all exams. We begin with Maharashtra CET Marathon for Legal Aptitude. Today I shall be discussing around some 20 important questions, 25 important questions with you. So bear with me for the entire session. A lot of information, a lot of knowledge coming up. But before we begin, BYJU'S exam prep. For this session, the agenda is there are certain 25 questions that I shall be discussing in the course of this session. BYJU'S exam prep brings to you a free workshop on why choose CLAT as a career on 9th of April at 6 p.m. Hurry up, register now. BYJU'S exam prep brings to you a scholarship test. Get up to 90% scholarship on our preparation program. BYJU'S exam prep brings to you a comprehensive course for CLAT 2024, wherein we shall be providing you with 300 plus recorded videos across 5 sections, 300 plus hours of live classes, 35 mock tests for CLAT and other law exam along with video solution, monthly e-magazine for current affairs, and the entire content is based and curated based on our extensive analysis of the last 5 years of CLAT. So hurry up, register now for CLAT 2024 comprehensive course brought to you by BYJU'S exam prep. Please read the principle. Up on your screen is a principle and certain facts. Requesting all of you to read the principle very carefully. State shall not make any law which takes away or abridges fundamental right, or any law made in contravention of this clause shall to the extent of contravention be void. So the legislature cannot make a law that is violative of your fundamental rights, and if they do it, the courts can strike it down. The government of Westeros came up with a law which made discrimination on the ground of religion valid. So the state made a law wherein two people can be discriminated on the basis of religion. Therefore, a person can now be discriminated based on his religion. This law was challenged in the court, and the court held that this law is void. From the opinions given below, provide which of the following reasons will justify the court's judgment. Very simple question. The passage says that, the principle says that if a law is made by the parliament or by this legislature, if it is violative of your fundamental right, that law can be struck down by a court of law. So the correct answer is option A. Discrimination against any citizen based on religion is prohibited under the law. Is prohibited. Right to religion. Any person can choose any religion. A person should not be discriminated. Am I clear? So, in these questions, we are trying to help you how to solve those questions which you might get in your exam. Am I clear, every one of you? Beautiful. Okay. If you are liking this session, please do share this session with your friends. Question number 2. Delivery of goods by one person to another for a purpose. Upon a contract that shall, when the purpose is accomplished, be returned or otherwise disposing according to the direction of the person. So, what is, girvi rakhna? That is what is explained. Delivery of goods, I require 1 lakh rupees in the middle of the night. I give you my bangle, golden bangle to you for your safekeeping. When I return that money, you return that things will be returned. You return me back the gold when I give you that 1 lakh rupees along with some interest. That is what is called. What is the correct answer? What is the correct answer? Very good. Bailment. Bailment का मतलब है गिरवी रखना. Delivery of goods for a particular purpose. After that contract is over, things are accomplished, you return back those goods. Simple. Bailment. Am I clear? So bailment is a delivery of goods by one person to another for a particular purpose upon a contract that they shall, when the purpose is accomplished, be returned. Am I clear? Okay, moving on. Question number 3. Which is that writ which can be issued by the Supreme Court to order government authority to perform its statutory function? It's very easy. It's called what? Very easy. It's called a mandamus. There are 5 different types of writs. Mandamus means a mandatory order. Do something. Now, if certain government's functionary is not performing its duty as per law, you can go to the court and get a mandamus directing a direction from the court, do your work as per law. Is that clear? To perform his statutory duty, the Supreme Court can direct that government authority to perform its statutory duty as given under the law. Question number 4. Let's read the principle. No child below the age of 14 years shall be employed in any work or in factory or mines engaged in hazardous employment. X was a child of 7 years, okay? His father's friend was the owner of a pesticide plant. X aspires to set up his own pesticide plant in future. He asked B to employ him. B employed him in his pesticide plant. C is a human right activist, moved the court against B. 7-year-old child, the law says below 14 years. Pesticide plant is a hazardous employment. Whether B will be held liable or not? Tell me fast. Whether B will be held liable or not? B will be held liable. Because you are engaging a child 7 years of age in a hazardous pesticide plant, glass factory, mines. These are hazardous employment. So the correct answer is option A. So option A is the right answer. All of you. No child below the age of 14 to be employed in hazardous employment. Pesticide is an hazardous employment. As simple as that. This is how we should solve these questions. Question number 5. Every agreement in restraint of marriage, if you are stopping someone from getting married, you are entering into an agreement stopping someone from getting into a marriage, other than a minor, is it void, voidable, valid, legal? Tell me fast, all of you. Jaldi. If you are entering into an agreement in restraint of a valid marriage between two legible individuals, that is a void. You cannot enter into an agreement like that. Coercion, undue influence, misrepresentation, fraud, voidable. But this is a void agreement. Am I clear, everyone? Section 26 of the Indian Contract Act says every agreement in restraint of marriage of any person other than a minor is void. Is that clear, every one of you? Am I clear to everyone? I hope that you guys are enjoying this session. I hope you are enjoying this session. If you're enjoying it, do press the like button. Question number 6. Principle. Subject to public order, morality, and health, all persons are equally entitled to freedom of conscience, right to freely profess, practice, and propagate religion. People belonging to X community filed a PIL in the Supreme Court to prohibit people from Y community from wearing black colors while offering prayers in their locality because they considered black color evil. Wearing black color was an essential practice of Y community. You have a right to wear black. I have a right to wear white. You should not interfere with my right to freely profess, practice, and propagate religion. I should not also do that. So, based on that thing, which of the following? People belonging to Y community needs to stop offering prayers? No. People belonging to Y community has a right to offer prayers in black cloths? True. People belonging to Y community has a right to freely profess, practice, propagate their own religion. So both B and C. So the correct answer is option D. The correct answer is option D. Is that clear? Moving on to question number 7. Every promise or a set of promises forming consideration is called a promise, set of promise. I promise to do something, you promise to do something for me. I promise that I'm going to sell my pen for rupees 10 and you promise that you are going to buy this pen for rupees 10. So the set of promise forming consideration for each other. Is it valid under the law? That's not said. So whether it has a binding legal relationship or not, that is not said. So as per that thing, it should be an agreement. Am I clear? It should be an agreement. An agreement that is enforceable by law, that is called a contract. So there is a difference. There is a difference. It is an agreement, not a contract. Mind you, a similar question did come in Maharashtra CET, I think a couple of years back. Okay. Please see. Every promise or a set of promises forming consideration for each other is called an agreement. 2E of the Indian Contract Act categorically states so. Moving on to question number 8. A person abates an offense who abates either the commission of the offense or the commission of an act, which would be an offense if committed by a person capable by law of committing that offense with the same intention or knowledge to do that better. So the principle of abatement is provided. Now what is abatement? If you are instigating someone, if you are helping someone in the commission of an offense. Now I buy you a gun and I tell you, go kill someone else. I am helping you. I am abating in the commission of an offense. A and B were friends. Difference arose between them. With time, B refused to return A's money. C, who was A's wife, asked A to take a revenge from B. She arranged a gun and gave it to A. A shot B, who survived the attack. Now let's see which of the following is correct. Is A liable? Who has committed abatement? The wife. C has committed the abatement. A has committed attempt to murder, whatever you call it. Attempt to murder, the punishment is the same. So the correct answer is which one? B. A is liable for murder. C is liable for abatement. Am I clear, all of you? Am I clear, everyone? Every one of you. So this is how we have to solve these questions. These questions are not difficult, but you should know how to solve these questions, the tricks. Okay, yeah, that's the solution to this question. Question number 9. Dash regional languages are listed under the 8th schedule of the Indian Constitution. How many? There are 22. Remember this. Legal knowledge will play a very crucial role for you. Legal knowledge. "22 legal language, regional language are listed under the 8th schedule. Very important legal knowledge. 10. Read the principle. An infringement of a legal right with or without injury frames the beginning of the offense of tort. A sets up a music school in his town and charges 10,000 per year. B sets up another music school opposite to A's school and charges 7,000 rupees every year. This made many students drop out of A's school and join B's school due to less fees. A sues B. Now I'm sure that you must have heard about the Gloucester Grammar School case, right? Now there is an existing school, a new school comes up just next to that old school. Lot of students get enrolled to the new school. The old school suffer financial losses because a lot of students have left them. Does it mean that their legal rights have been violated? Unless and until there is a violation of a legal right, it is not a case in which you can claim compensation. So the correct answer is A will not succeed, because there was damage without legal injury. Unless and until your rights are violated, you cannot claim compensation. Damnam sine injuria, damage without injury. Yeah. I hope that you guys are getting to understand all these things. Good. If you're liking this session, do press the like button. What are you waiting for? Fast. Jaldi like kar do. Okay, moving on to the next question. Question number 11. Let's read the principle. Any direct physical interference with goods of somebody's possession, lawful justification, is called trespass. Very easy. A purchased the sofa from B. D, who believed that the sofa was his, removed it from A's house. Oh, D removes A's sofa from his house. A filed a suit of trespass. Absolutely, D is liable for trespass. Now, if I take a sofa from your house thinking that it belongs to me, it is a case of trespass. So the correct answer is am I clear, everyone? Okay, moving on to question number 12. Landmark judgment of Keshavananda Bharati for the state of Kerala is associated with what? Fundamental right, basic structure, armed rebellion. This is emergency. This cannot be. Both A and B. Option D is the right answer. That is how fast you should do. This is how fast one should answer a question. You should not take time. I am also solving these questions with you so that to give you an impression how to solve these questions fatafat. Question number 13. When a criminal act is done by several persons in further to a common intention, each of such person will be liable as the act in the same manner as if it was done by him alone. So conspiracy, the principle of conspiracy is provided. A and B conspired to kill C by poisoning him. A brought the poison, B mixed it and gave it to C. C drank, C died. What offense has A and B committed? When two or more than two people with the intention of doing something wrong commits a wrong, each and every person will be liable as if he had done the entire thing by himself. So the correct answer is A and B both have committed the offense of murder. Yes, under this principle. Okay. Question number 14. No person shall be prosecuted or punished for the same offense more than once. A was found harassing his female colleague. She filed a criminal case of sexual harassment against A and was sentenced to 2 years of imprisonment. After serving the punishment, the post committee, that is the internal committee of the company, found him guilty and fired him. Now, does it amount to double jeopardy? The question is, does it amount to double jeopardy? The second punishment is given by the company. The first was given by the court. Under the law, it will not amount to double jeopardy. Both the two punishments are absolutely different. Only punishment under the law means anything that is given by a court. It does not amount to second punishment. Am I clear? Is that clear? Every one of you. So did you understand? Are you understanding, guys? This is how easy it is to solve the question. Question number 15 before you. A contract is an agreement enforceable by law. All agreements are contracts if they are made with free consent of parties eligible to enter into a contract for a legal object. A offered to sell his bike to B for 5 lakh. B denied the offer, which made A furious. A decided to kill B by pointing his gun at his age. In the fear of death, B consented to the deal. Has he done it under free consent? Free consent of the parties. You keep a gun on someone's forehead and say, enter into the contract. Is it a valid contract? Let's see. Is that agreement enforceable by law? Valid, not enforceable, valid contract. And the correct answer is, it is not enforceable. It is not enforceable. So easy. There is something called coercion, right? In this case, coercion was used. Question number 16. A bailment of goods as security for payment of a debt or performance of a promise is called what? Murder, culpable homicide, rape, or pledge. Very easy. Very easy. It's not murder, culpable homicide, or rape. It's called pledge. आपका जो महाराष्ट्र सीईटी का जो एग्जाम होगा वो बहुत डिफिकल्ट एग्जाम नहीं होगा. फर्स्ट एंड फॉरमोस्ट, आपका जो क्वेश्चन है डिफिकल्ट, बहुत ज्यादा क्लैट वाला या एलेट वाला डिफिकल्टी लेवल नहीं रहेगा. नंबर 2, आपको आराम से क्वेश्चन पढ़ोगे, आंसर आपको आराम से आ ही जाएगा. इट इज सो इजी. Bailment of goods as security of payment is called pledge. Question number 17. Read. Whosoever intending to take dishonestly any movable property out of the possession of a person without that person's consent moves that property has committed theft. A was out of town for a week due to his business trip, so he decided to entrust his Persian cat to B, his neighbor, for 1 week with some money to take care of his Persian cat. B, who was tired of the cat, of running away, carries her to a pet shop and sells it. When A returns, he files a case of theft. Is it a case of theft? Has he taken that cat without the authority of the master? The master himself came and gave that cat to entrust upon him. How can this be a theft? Please try to understand. आप अमेरिका जा रहे हैं, आपके पास एक बिल्ली है, आप आपके दोस्त के घर में रख के गए, भाई तू देख लेना. Am I clear? भाई तू देख लेना. वो आपका बिल्ली को बेच देता है. Is it theft? No, it is not. Without his permission, without the owner's permission, was it taken away? No. Okay. 18. Every person has a right to defend against any offense affecting his human body. His own body, body of any other person, only own body, both A and B. His body and any other person. Not only own body. No, it cannot be. So both A and B is the correct answer. So easy. So easy to solve these questions, guys. These questions are not at all difficult to solve. I'm solving these questions with you. Question number 19. state can make provision for the reservation on an appointment in favor of a backward class of citizen, which in the opinion of the state is not adequately represented in the services under the state. So there is right to equal employment, but the state can make special laws, for example, reservation for in favor of a particular backward class. And it has to be proven that in the opinion of the state they are not adequately represented in that services. The government of the state comes up with a law which reserve 20% seats belonging to Y community, which is the backward community. As per the opinion of the state, the community is not adequately represented in the services under the state. A belongs to Z community, files a writ petition against the law providing reservation to Y community on the ground that infringes fundamental right to be treated equally. Now the state is provided with the power to make provision for the upliftment of the backward classes, yes or no? Is it stated in the fact that based on the fact that these X community is not represented properly, they have come up with this law of 20% reservation? What's wrong? Does the state have the power? Yes. Has it done it as per law? Yes. So the correct answer is, am I clear to each and every one? Am I clear to each and every one of you? Tell me that. Okay. Moving on to question number 20. Okay. A, B, C, D. Ryland versus Fletcher. Ryland versus Fletcher. This landmark judgment relates to what? Consensus ad item, vicarious liability, murder, or strict liability? I'm sure everyone will give me the right answer, at least to this question. Ryland versus Fletcher. There were two neighbors. One had a huge water reservoir, the other had a coal mine. There was some problem with the water reservoir. There was a shaft was broken. Water leaked out from the water reservoir, entered into the other person's coal mine. The coal mine got destroyed. That gave rise to the concept of strict liability. That gave the rise to the concept of strict liability under the law. Am I clear to everyone? Am I clear to everyone? Is that clear? Tell me. If it is not clear, I will tell you. Do you remember Ryland versus Fletcher, all of you? All of you? Thank you. Thank you. Good. Question number 21. Causing or allowing to cause escape of any deleterious thing from one's land to the others without lawful justification amounts to nuisance. A's hobby was gardening. He used to collect and grow rare plants in his garden. Once he went to his friend's B's house and asked him about an attractive plant, to which B replied that it was a poisonous wild plant. A brought some seeds of that flower and started growing in his garden. The branches of the tree expanded and crossed into A's boundary and reached on his neighbor C's premises. C's cow ate the flowers, got sick because of that poisonous thing. C files a civil suit of nuisance against A for damages. Very easy. You have grown a poisonous plant in your premise. It has become big. The leaves have moved out of your campus and your neighbor's cow has eaten some flowers and has fallen sick. The first question, yeah. Is liable for nuisance, is not liable for nuisance. As per the principle, stick to the principle. Do not get into strict liability, absolute liability. No, no, no. Very good. A is liable for nuisance. A is liable for nuisance. There is no doubt about it. Okay. Question number 22. Which of the following judgment prostitutes and sex workers, right to life with human dignity under Article 21 was upheld? Navdeep Singh Johar, LGBT right. Joseph Stein, no. Young lawyers, no. Buddhadev Karmakar versus State of West Bengal. Buddhadev versus State of West Bengal is the case. Very, very important. Okay, very easy, very easy. The Supreme Court upheld that prostitutes and sex workers have the right to live with dignity. Navdeep Singh Johar is consensual intercourse between homosexuals, LGBT. Joseph Shine decriminalizes adultery. Young lawyers versus state overruled old practices of prohibition of entry into the Sabrimala temple. Is that clear? All of you? Okay. I hope that you guys are understanding this session well. Question number 23 is up on your screen. Consent can be a good defense in tort if the defendant proves that the plaintiff agreed to the potential risk and consequence involved in the act which led to damages. A and B decided to resolve a disagreement through wrestling. While wrestling, B got injured through a punch. He has filed a civil case for damages. As per the principle. Let's see what is the correct answer. The correct answer is option C. Yes. They decided to resolve the disagreement through wrestling. They decided. A and B decided to resolve the thing by wrestling. Am I clear how to solve these questions? Not difficult, guys. It is not at all difficult. Just that you have to be smart. फटाफट क्वेश्चन पढ़ोगे, आंसर में देखोगे. Easy है. 24. A collegium system of appointment and transfer of judges was introduced by the Supreme Court by which of the following judgments? Okay. Supreme Court Advocates on Records Association, ex-captain Harish Uppal leads with the fact that there cannot be a strike by lawyers. D.K. Basu deals with protection of arrested people. Maneka Gandhi, right to life, right to travel abroad. So the correct answer is Supreme Court Advocates Association versus Union of India. Supreme Court Advocates on Record Association, SCORA, SCAORA versus Union of India. Very easy. The collegium system was introduced by SC Advocates on Record Association. Ex-captain Harish Uppal deals with lawyers do not have a right to go for strike. D.K. Basu dealt with guidelines preventing custodial violence. Maneka Gandhi, right to life, right to the procedure established by law. So, and introduced the due process of law. That means your life cannot be taken away without the due process of law or without the procedure that is established by law. Question number 25. Read the question very carefully. Senti non fit injuria, which means only risk, only knowledge of the risk is not enough to claim defense. Now, voluntary non fit injuria, you know, So just if you have the knowledge of the risk, you can claim compensation. A's train was running late and he had an appointment and had an important family function to attend. He asked B to drop him to his destination, to which B replied that the brakes of the car are not working properly. But there is no need to worry because the car has emergency brakes. On their way to drop B, B's brake fails and the car meets with an accident. A, who suffered injury, filed a suit against B for negligence. That's a question. Simple. The options. B is liable for A's injury. B is not liable. B was dropping. A was relieving the truth about brake failures. A understood the risk and consented to suffer the same. Is B liable? And the correct answer is B is liable for A's injury. Why? Because A only knew about the risk, which is not enough to claim defense of consent. There must be acceptance to undergo the risk undertaken, which is absent in the above case. Am I clear? Is that clear to everyone? Is that clear? Every one of you? Fantastic. So these were the 25 questions that we had in this marathon round. There will be many more coming up just for you guys. So guys, BYJU'S Exam Prep brings to you CLAT 2024 comprehensive course, wherein we are providing you with 300 plus recorded videos across 5 sections, 300 hours of live classes, 35 mock tests for CLAT and other law entrance examination along with video solutions, monthly e-magazine for current affairs, and the entire content is based on our analysis of the last 5 years of CLAT question paper. Guys, there is a free workshop going on. Why choose CLAT as a career? Hurry up, register now. So guys, if you did watch and did you enjoy today's session, I will understand it from your chat as well as from your likes. If you liked it, do press the like button and subscribe to our YouTube channel. Follow us on our Instagram page. Do like our Facebook page. Do join our Telegram channel. And just do not forget to download our BYJU'S Exam Prep app today from Google Play. So guys, with this, we come to the end of this session. Thank you very much. God bless you. Stay home, stay safe, stay healthy. Have a great weekend ahead. Bye-bye. Take care. All the best. Ta-da.